The Constitution of Great Britain has always been a subject of controversy among the constitutional writers. Alexis de Tocqueville, the famous French writer, once remarked, "In England there is no constitution." De Tocqueville was led to this conclusion because he was accustomed to regard a written document properly adopted as a constitution, which the British Constitution is not. It is a unique constitution because it is unwritten, extremely flexible, evolved mostly by parliamentary enactments and conventions, and not safeguarded by a special body, such as the law courts, but left to the free decisions of the legislature. These and other features of the British Constitution make it a difficult constitution to describe in print. It is a living reality, constantly changing and evolving, under its internal pressures and external forces. It is, as Joseph Redlich said, an infinitely complex amalgam of institutions, and principles and practices. It is not one document, but thousands of them. It is not derived from one source, but from several. It is not complete but is in the process of growth. It is a child of wisdom and of chance, whose course has been indifferently guided by accident, and by design and deliberation. It is a child of accident and chance. It comprises the following elements or ingredients, which, taken as a whole, makes what we call the Constitution of the Great Britain. Great charters, and other constitutional landmarks. These include such charters, petitions, statutes and historic documents, which embody solemn agreements, at the time of great political struggles and crises or changes. These are the Magna Carta, 1215, the Petition of Rights, 1628, the Settlement Act, 1701, the Great Reform Act, 1832, the Parliament Acts of 1911 and 1949. These were not passed in normal times, and not even by normal legislative procedure, but as a result of a political struggle. The adoption of each of them proved to be a turning point in the constitutional history of the country, when some new constitutional principle or institution was established, or began to evolve. Nearly 1,000 years of such struggles and crises have made this constitution what it is today. Statutes, or Acts of Parliament. These are the ordinary enactments of Parliament, called statutes, passed by it in a normal manner, but have constitutional significance, or importance. These define the powers of the Crown, guarantee private rights, establish institutions, limit functions and powers of various public bodies, establish law courts, define methods of holding elections, franchise, etc. These would be designated constitutional in countries which have written constitutions. These are, for example, the Habeas Corpus Act 1679, the Septennial Act of 1716, the Municipal Corporations Act 1835, the Judicature Acts 1873-6, Representation of the People Act 1949. Judicial decisions. The decisions of the law courts are another important source of the English Constitution. These form its important elements because these interpret and explain the provisions of the various constitutional charters and statutes. Most of the rights enjoyed by the English people are derived from the decisions of the courts, pronounced in cases contested before them. They are, for instance, the decision in Bushel's case 1670 which defined the independence of juries, the decision in Howell's case 1678 which established the principle of immunity of the judges, etc. By common law is meant that body of legal rules which grew up in England and got recognition but without any enactment by Parliament. It was evolved by judicial decisions. The common law is the unwritten part of the English Constitution. Most of the rights and liberties of the Englishman, the prerogatives of the Crown, trial by jury, the rule of law, etc., are derived from the common law. Constitutional conventions, usages etc. form the fifth element of the English Constitution. These are its unwritten parts, and are of fundamental importance.